Hello, it's Brodie McLeod here again, doing a bit of vlogging, mate. Just doing a bit of vlogging, keeping my hand in. Might be several questions that you've got, like, why am I releasing a vlog at 2 o'clock in the morning? Why am I wearing my coat inside in a hospital? Why is it that the NHS is ignoring quite an important inquiry? All of these questions I'll endeavour to answer for you if they're playing on your mind, and if they're not, then I guess you haven't watched any of the other videos. Got this new smartwatch, right? 50 quid, renewed Galaxy Watch 4. It's not as good as the newer ones, but it's pretty handy. It's got a sleep timer on it, right? And according to this, I've been asleep since 9:50 p.m, which is about an hour and a half after I took my evening meds, my clonazepam, which makes you a bit sleepy, and woke up at 1:22. Don't know why I woke up at 1:22. I wake up during the night a lot of the time, so I've had 3 hours and 11 minutes of sleep time, a sleep score of 43, which requires attention. If you can see, there's like 2 stages there of movement, sort of quite distinct movement activity. You can't really see this, those orange spikes. Says here that during my sleep I was awake for 21 minutes. It says there, that's that little orange dot, awake for 21 minutes. Only had 20 minutes of REM sleep, 2 hours and 32 minutes of light sleep, and 19 minutes of deep sleep. My blood oxygen level was down to 90% at one point. My average heart rate was 67, but it ranged between 54 and 84. 84 is quite a high resting heart rate for me. I've put on a lot of timber around my belly over the last few years, being on depot injections. But yeah, 80 would still be me with a kind of quite a high resting heart rate. Anyway, this video is about an inquiry I've made to the NHS, and a bit of a weird thing that's happened to me that nobody has attempted or given any credence to trying to kind of explain or answer to me. It's just been this kind of mysterious, malfeasant, sort of stressful, worrying thing that's happened. So the recycle bin was just making some space. I got a visit on the 22nd of July from this dude, Mark Stowe, and he gave me his email address during the meeting. I've read this before in previous videos, but this is going to be a bumper length, probably half an hour video, so get yourself a cup of tea and a biscuit if you're so sad that you watch these. So I wrote to him with this kind of AI composed letter, because it knew the laws far better than I did about the way that, as a Bristol resident for 4 years, I should have been treated by AWP, not Devon Partnership Trust, where this chap works. They just told me he'd come in to visit me and that I had a meeting, and so I attended it, and he was quite polite, but actually has just been useless since then, in between his holidays, which fit quite neatly around my ward round and my detention. I said, "Dear Mark, I'm writing to address the current funding arrangement for my detention under Section 3 of the Mental Health Act 1983. I understand NHS Devon Partnership Trust is currently listed as the funding commissioner, despite my having been ordinarily resident in Bristol for the past 4 years. I wish to clearly state that in accordance with established NHS funding principles and legal guidance, the responsibility for commissioning funding my current Section 3 detention should lie with NHS Avon and Wiltshire Partnership Trust, as they are the integrated care board for the area in which I am and have been ordinarily resident. Here are the key points supporting my position. The principle of ordinary residence for detentions. The fundamental principle governing responsibility for NHS healthcare funding, including detentions under the Mental Health Act, is a patient's ordinary residence. This is consistently affirmed in NHS England Who Pays guidance. Ordinary residence refers to the place where a person has voluntarily adopted a settled purpose as part of the regular order of their life, which I had, whether for a short or long duration. My 4 years of continuous residence in Bristol clearly establishes this. The NHS England's Who Pays guidance. The Who Pays determining which NHS Commissioner is responsible for commissioning healthcare services and making payments to providers guidance, most recently updated April 24, outlines the rules. For mental health detentions, the responsible integrated care board is generally determined by where the patient was ordinary resident immediately before their detention. As I've been ordinarily resident in Bristol for 4 years, my ordinary residence immediately prior to this current Section 3 detention was clearly within the Bristol area, meaning the commissioning responsibility lies with the relevant ICB for Bristol, which is Avon and Wiltshire Partnership. Distinction between Section 117 aftercare and the Supreme Court ruling. It's important to differentiate the funding for a Section 3 from that of a Section 117 aftercare services. While the Supreme Court case Worcestershire versus R, Secretary of State for Health and Social Care in 2023, Swindon versus Worcester ruling brought significant clarity to the determination of responsibility for Section 117 aftercare services following re-detention. Kind of complicated jargon you don't need to worry about in case law. It reinforced the principle of ordinary residence as being central. The Supreme Court specifically stated that a Section 117 duty ceases upon re-detention and a new Section 117 duty arises upon subsequent discharge, with the responsibility falling to the ICB and the local authority for the immediately before that latest detention. This ruling, while focused on aftercare, underscores the legal emphasis on the most recent place of ordinary residence as the determinant for new duties and responsibilities. It does not support a first funder principle for current detentions when ordinary residence has to be changed. So first funder, for anyone that's not familiar with that term, it used to be this really weird system where if you got sectioned in London in the year 2000, you didn't get sectioned again for another 15 years and you'd moved to Liverpool, your funding would still be with the first NHS trust in London that sectioned you, and they would always fund you. It used to be like that, but it's not like that anymore. It hasn't been like that for many years now, but there used to be a first funder, and that's what this is talking about in inverted commas there. First funder, or quotation marks either, to be a bit of a grammar Nazi against myself. Principle for current detentions when ordinary residence is clearly changed. No first funder rule for current Section 3 detentions. The concept of a first funder retaining indefinite responsibility generally relates to ongoing Section 117 aftercare that was initiated by a particular commissioner and may have been subject to complex historical rules prior to that Supreme Court case going through. That's the Swindon versus Worcester one I mentioned a minute ago. Does not apply to the funding of a new or current Section 3 detention where a person's ordinary residence has unequivocally shifted, which it has. I'd moved to Bristol in 2021 and was sectioned again for this detention in 2024, in July. My current detention is a new event triggered by my current circumstances, for which the local ICB should be responsible based on my established residence. Practical and ethical implications. Continuing to have Devon Partnership Trust fund my detention despite my long-term residence in Bristol creates practical difficulties and is contrary to the spirit of locally delivered care. My local mental health trust, NHS AWP, is best placed to understand and manage my ongoing care needs, integrate with local community services and facilitate my recovery and eventual discharge back into the community where I live. This arrangement ensures continuity of care and appropriate resource allocation for residents. Therefore, I respectfully request that NHS Devon Partnership Trust reviews my funding status and formally transfers the responsibility for my Section 3 detention funding to NHS Avon and Wiltshire Partnership. My ordinary residence for the past 4 years in Bristol clearly establishes this as the appropriate and legally sound arrangement. I'm available to discuss this further and provide any additional information required. Thank you for your time. That was on the 22nd of July. Now, this shouldn't have taken like any more than about 30 seconds. Like, it took me about 10 minutes to get myself sort of educated and understanding the rules and regulations. I did that just by Googling it. Now, people at NHS sort of senior positions and, integrated care boards and even care coordinators or key workers have also got should have the foreknowledge, and if not, the resources and capacity to be able to very quickly identify, okay, this Brodie McLeod chap, where's he lived? Oh, he's lived in Bristol on Wells Road and also at Talbot Avenue since 2021 in 2 different supported accommodations. And he spent a bit of time in hospital in between, but he's been resident in those places. So why are we changing his integrated care board and NHS funder halfway through his detention with no good reason? Saw a quote on the internet earlier, and it sort of said, before the internet, we used to think that kind of stupidity was because people didn't have access to all the information that they kind of needed. And then it sort of said, but with the rise of the internet, it's like, yeah, well, it wasn't that. People are still stupid, even though they've got access to all of the resources and information. We've all got Google and AI in our pockets now. ChatGPT is ubiquitous, but it hasn't made us smarter. And people still seem to be able to be, acting under this veil of ignorance or stupidity, even though they've got the resources at their fingertips. Anyway, that email, I emailed on the 28th of August, about a month later. I still hadn't heard anything back. So I sent emails to both AWP and Devon Partnership Trust PALS teams. I find the email, I can't see the email that I sent to them, but when they sent me an acknowledgement on the 28th of August, I sent one back. I said, hello, while I understand the pressures you're under regarding resources, I'm writing to strongly emphasise that the nature of my complaint necessitates an immediate and prioritised investigation. The issues I've raised are not a routine service complaint, but concern the fundamental legality of my ongoing detention. My core contention is that the transfer of my care and detention from Avon and Wiltshire Mental Health Partnership Trust to Devon Partnership Trust was procedurally improper and based on a flawed determination of my ordinary residence. Consequently, my continued detention under the authority of DPT may be unlawful. Aside from the NHS Who Pays guidance, which dictates financial responsibility, the decision to transfer responsibility for my detention brings into focus serious breaches of primary legislation and statutory duties. The specific legal frameworks being contravened include the Mental Health Act 1983. So the Section 117 Aftercare section places a joint duty on an integrated care board and local authority for the area in which I was ordinarily resident, Bristol, prior to my detention to provide aftercare. This misidentification of this area directly impacts the lawfulness of decisions made about my placement and care. Human Rights Act 98, ongoing detention under these circumstances potentially breaches my fundamental human rights. Article 5, the right to liberty and security. Deprivation of a person's liberty is only permissible when it's carried out in accordance with a procedure prescribed by law. If my transfer from the detaining authority of AWP to DPT was procedurally flawed, then my current detention lacks a lawful basis, constituting an arbitrary and unlawful deprivation of my liberty under Article 5. The issue of potential unlawful detention must be prioritised above all other service complaints. The state's power to deprive a citizen of their liberty is its most draconian, and it must be exercised with scrupulous adherence to the law. Any deviation that renders a detention unlawful is a matter of the highest gravity and requires immediate remedy. Must also highlight that I've already sought to resolve this through the appropriate channels. I raised these exact concerns in significant detail. Mr. Mark Stowe, the repatriation coordinator for Devon Partnership Trust Devon Partnership NHS Trust, during a face-to-face meeting on the 15th of July. I don't know if that's the right date. The email was a different date. Maybe it was the 15th. Fuck knows, can't remember. During that meeting, Mr. Stowe acknowledged the seriousness of the legal points I raised when I emailed him that email that I just showed you, and agreed to refer it to his superiors for review. This was provided in detail to him via email during our meeting. The review should naturally have involved communication with AWP. It's now been over 4 weeks since that meeting, and I've received no substantive substantive response or explanation from either DPT or AWP. From my perspective, this timescale is wholly unreasonable and unacceptable for a matter concerning the legality of my detention. Given that my liberties at stake, I expect a substantive report that directly addresses the legal and procedural points raised in this email. As a matter of extreme urgency, please advise me of the immediate actions you're taking to investigate this critical issue. Mark got back to me on that day, said he was on leave until 1st of September, and I haven't heard from him since. I did a bit more research. This prompt is not being me being an uber genius, but is actually a prompt that I got AI to generate, so that I put in everything I wanted to find out, and then I got AI to generate a prompt for itself and then put that into it so that I would get the best results. The results aren't perfect in this. It says that but I am being funded by AWP, which I'm not, as far as I've been led to believe. Anyway, I'll get into reading it. It's already 16 minutes into the video, and you might have found your eyes rolling back into your sockets, or you're self-feeling sleepy, a bit like you've just been hypnotised. So I'll move this widget out the way. Can I put this fucking widget? I'll just keep it in the top corner. It says, act as a specialist legal and healthcare policy research assistant. My objective is to conduct a deep and thorough analysis of the lawfulness of my current detention under the Mental Health Act 1983, based on the specific circumstances outlined below. Please provide detailed explanations citing all relevant legislation, including specific sections, official guidance, statutory instruments, NHS policies and case law where applicable. Factual background. I'm a patient currently detained under the Mental Health Act 1983. My detaining authority is Avon and Wiltshire Mental Health Partnership Trust, NHS, or it should be. It should be. It's not. That's wrong, basically. It's Devon Partnership Trust is what I've been resoundingly informed. So that's an error that I didn't kind of make clear. The central issue is that AWP NHS is attempting to, or has already, so it isn't completely wrong, transferred the funding and commissioning responsibility for my hospital treatment to Devon Partnership NHS Trust. This action is being taken despite the fact I've been ordinarily resident in Bristol, which falls under AWP's geographical area, for the last 4 years. The issue is not new. I've been actively trying to resolve it. On the 22nd of July, not the 15th, I personally emailed the repatriation coordinator for DPT NHS. This coordinator subsequently met me in person at my current location. This establishes that DPT has had direct, explicit knowledge of my situation and the commissioning dispute since that date. Despite both the AWP and DPT being aware of this urgent, serious issue since the 22nd of July, no action was taken by either trust to resolve it. I was ignored. Consequently, on the 28th of August, I was forced to raise the issue formally with the Patient Advice Liaison Service, PALS, teams for both NHS, AWP and DPT NHS. To date, I've only received acknowledgement emails and no substantive response or resolution. The situation has not caused me extreme stress, but it has made me feel vulnerable, worried and ignored by the very services responsible for my care and lawful detention. So here are the research tasks. Please structure your research and respond into the following 4 distinct sections. First, the illegality of the detention due to incorrect commissioning. Explain in detail the principle of ordinary residence as defined by the Care Act 2014 and the relevant NHS Who Pays guidance. How is ordinary residence determined for a patient who has lived in a new area for 4 years? Detail the legal responsibilities of the responsible commissioner for a patient detained under the Mental Health Act 1983. Critically analyse how having the incorrect NHS trust responsible for commissioning and funding, i.e. DPT instead of AWP, can render a patient's detention unlawful. Focus on the following points: the duty of the responsible commissioner to be involved in care planning, treatment reviews and meetings, e.g. care programme approach meetings, specific duties under section 117 of the Mental Health Act 1983, aftercare, which places a joint duty on the local social services authority and the responsible NHS commissioning body to provide aftercare services if the incorrect NHS body is identified. How does this legally compromise the planning and provision of a lawful discharge and aftercare package? How does this administrative/funding error constitute a breach of the legal framework of the Mental Health Act and associated code of practice, potentially violating my rights under Article 5 of the European Convention on Human Rights, the right to liberty and security of person, breaches of duty, Section 2, and regulatory failings by the NHS Trust based on the timeline: initial contact 22nd of July, powers complaint 28th of August, and no resolution to date. Please detail the specific breaches of duty by both NHS Trusts. Cite relevant regulations, NHS constitutional rights and guidance regarding intertrust communication, dispute resolution, especially concerning funding and responsibility, and the expected timeframes for resolving serious patient complaints. Explain the role and responsibilities of PALs and standards of service I should have expected. How does their failure to provide a substantive response constitute a failing in itself? Discuss the concept of the statutory duty of candour and whether the Trust's collective silence and inaction could be considered a breach of this duty. Potential for litigation and legal remedies. Explore the potential legal actions I could take. Please discuss the viability and process for judicial review to compel AWP and DPT to correctly determine my ordinary residence, and for AWP to accept its responsibility as the responsible commissioner. Claim for damages for unlawful detention or false imprisonment. Explain how the period of detention could be argued as unlawful from the point that the trusts were made aware of the commissioning error but failed to rectify. A claim under the Human Rights Act 98 for breach of my Article 5 rights. Provide an analysis of the potential value of such litigation. What factors would a court consider when awarding damages for this type of oversight? Disregard for legal and medical compliance. Please incorporate the emotional impact I've described, which is not severe, but it has made me feel vulnerable. I don't really trust Devon Partnership Trust. I don't know why I'm constantly boomeranging back to them, and I'm kind of worried, and they've just ignored me. So that's how I feel. Not great, really. Kind of quite stressed out. Guidance on next steps for a litigant in person. Given that I've been unsuccessful in securing legal representation, please provide a clear step-by-step guide on what I can do to advocate for myself and ensure my rights are protected. What's the next step after Powers has failed to respond? Should I initiate a formal NHS complaint? Explain the roles of the following bodies and how I can effectively engage with them. The Independent Mental Health Advocates, which have all been about as much use as a chocolate fire guard. Care Quality Commission, CQC, who haven't been great either. They don't really do anything except for periodic checks. Whilst they're interested in these kind of things, specifically regarding their role in ensuring services comply with the Mental Health Act, and the PHSO, Parliamentary and Health Services Ombudsman. It used to be different. It used to be called the Parliamentary, it used to be called something else, but now it's called the PHSO. What evidence should I be meticulously collecting and documenting from this point forward? Please ensure all assertions are backed up by citations from primary sources, Acts of Parliament, official guidance from NHS England, the MHS Code of Practice, etc., wherever possible. So here's the plan it put together. Let me know if you need any changes before I start researching. It did a research thing, and I'm going to read it to you now, which might take fucking ages. So get the kettle on and have a cup of tea and a biscuit if you need it. This is quite long, and I'm going to remove my ugly mug from this because it makes it easier to read, and this floating UFO thing can just go over there. An analysis of the lawfulness of detention under the Mental Health Act 1983 in the context of a commissioning responsibility dispute. Executive summary. This report provides a detailed legal and policy analysis concerning the lawfulness of a patient's current detention under the Mental Health Act. The central issue is a dispute between Avon and Wiltshire Mental Health Partnership NHS Trust and Devon Partnership NHS Trust over which body is the responsible commissioner for the patient's care and treatment. The patient has been ordinarily resident in Bristol for 4 years, placing commissioning responsibilities squarely with AWP. This report finds that the failure of both trusts to resolve this dispute since being formally notified on the 22nd of July. I don't know where the 15th of July came from, but that was definitely bouncing around a minute ago. I don't know. It's not a mere administrative oversight. It's a fundamental procedural failure that's created a legal vacuum, rendering the lawful planning of the patient's discharge and aftercare under Section 117 of the MHA impossible. This breakdown of the statutory framework means the continued detention is no longer fully in accordance with the procedure prescribed by law. Thereby, it says, becoming arbitrary and consulting a potential breach of the patient's right to liberty under Article 5 of the European Convention on Human Rights. The report details the specific breaches of duty by the trust, including failures in dispute resolution and a breach of the statutory duty of candour. It further outlines potential legal remedies, including judicial review to compel lawful action and claims for damages for unlawful detention and breach of human rights. Finally, it provides a structured guide on immediate next steps for the patient to pursue as a litigant in person, including escalating the matter to a formal complaint and engaging with statutory bodies such as the IMHA, which is just sort of there to assist you with stuff you can't do. My experience is that they've actually just stuck up for the hospital with like other complaints, and the CQC, who again don't kind of advocate in any immediate sense. They just kind of write down statistics and factor it into their next inspection. And the Parliamentary and Health Service Ombudsman, who I've never had any dealings with, but I might have to escalate to. Section 1 of this boring document: the illegality of the detention due to incorrect commissioning. 1.1. The principle of ordinary residence, a legal determination. The foundation for establishing which NHS body is legally and financially responsible for a patient's care rests on the principle of ordinary residence. This concept determines which integrated care board, and by extension, which NHS trust is the responsible commissioner. The term ordinary residence, not defined within the Care Act 2014. Its meaning has been established through a significant body of case law. The seminal case, blah, 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 in which Lord Scarman defined ordinary residence as a person's abode in a particular place, which he has adopted voluntarily for settled purposes as part of the regular order of his life at the time being, whether of short or long duration. Critically, there is no minimum period required to establish ordinary residence. It's the nature and quality of the person's connection with the area that's paramount. In the present case, having lived in Bristol for the last 4 years, the patient has clearly established ordinary residence there. This was a voluntary move for a settled purpose, satisfying the SHAR test, whatever the fuck that is. Evidence such as tenancy agreements, council tax payments, or local connections would further cement this fact. I've got all of those available. This legal principle is operationalised within the health service by the NHS's statutory Who Pays guidance. This framework is unambiguous in its purpose: to allocate legal and financial responsibility and to prevent public bodies from attempting to export responsibility for an individual to another area. The guidance specifies that when a patient moves to a new area, registers with the GP, the ICB for that new area becomes the responsible commissioner. Therefore, the ICB covering the Bristol area, which commissions services from AWP, is the responsible commissioner. The deeming provisions within the Care Act 2014, which in some circumstances treat a person as remaining ordinarily resident in a previous area when placed in specified accommodation, such as NHS accommodation or a care home, do not apply in this instance. The move to Bristol occurred 4 years prior to the current detention and was not a voluntary act, not a placement by another authority. 1.2. The role and duties of the responsible commissioner. The role of the responsible commissioner extends far beyond simply paying for services. It's an active, participatory role with significant non-financial duties that are integral to the patient's care, treatment and legal rights. These duties are outlined in the Mental Health Act 1983 Code of Practice, a statutory guidance document to which professionals must have regard. The Code of Practice mandates a holistic and patient-centred approach, emphasising that patients should be enabled to contribute fully to their care and treatment plans. The responsible commissioner is a key statutory partner in this process. They hold the duty to ensure that the services they commission are safe, effective, and meet specific needs of the individual patient. This involves active oversight of care planning, ensuring the treatment reviews are conducted properly and that all planning is directed towards the patient's recovery and eventual discharge. The absence of the correctly identified responsible commissioner means there is no legally accountable body overseeing the appropriateness of the care being commissioned and delivered. 1.3. The impact of incorrect commissioning on the lawful detention. This is kind of one of the main bits. So I just had to pause there. Someone came to the door. Didn't want them to be present in the video. Doing the hourly obs early. They did my last obs at 2 o'clock. They're doing the next one 50 minutes later. So they're 10 minutes early. Very prompt of them. Anyway, the incorrect commissioning on lawful detention impact I was just reading. The failure to correctly identify and involve the responsible commissioner is not a peripheral administrative error. It strikes at the heart of the legal justification for detention. Detention under the Mental Health Act is not a punitive measure. Its sole lawful purpose is to provide assessment and or medical treatment. In my case, it's a Section 3 treatment order that the person cannot receive on a voluntary basis, with the ultimate aim of promoting recovery and facilitating a safe discharge back into the community. This therapeutic purpose requires a robust, legally compliant framework of care planning and review involving all relevant statutory bodies. In this case, NHS DPT incorrectly identified and NHS AWP failing to accept its legal responsibility. A legal vacuum has been created. There's no correctly identified responsible commissioner fulfilling its statutory duties. Consequently, the patient's care planning, treatment reviews and discharge planning are not being lawfully constituted. Decisions about care and treatment being made without the involvement and oversight of the very public body that is legally responsible for ensuring their appropriateness and commissioning the services necessary to progress the patient's recovery. So just for a bit of insight and inside info, my last ward round, there was nobody. So this Mark Stowe guy wasn't there. My ward round was on the 1st, and he said he was on holiday until the 1st. They said I had to wait outside the ward round for like about 25 minutes until it was meant to be at 11. I got in there at about 11:30, 25 to 12, because they said that teams had broken. So there was no qualification of whether AWP or DPT were going to be completing what we did in that meeting, which was go through my care plan with one of the support workers and input some bits. I think they were just sort of trying to cover their arse and say, well, look, you know, his care plan isn't being neglected, therefore we're not committing criminal negligence or medical negligence by neglecting the care plan. Care plan's just some kind of shitty document where you sort of set goals and say how you feel about certain things. And they updated the care plan in my ward round, and that's about all we did. But I think that was just a sort of getting that base covered so that I haven't got grounds for medical negligence quite so astutely, although astute's not even a fucking word. Astutely might be a word. Yeah, we did my care plan in my last ward round, but the NHS commissioner should be responsible for kind of overseeing that that's done properly, whilst it's the job of the hospital and the registered mental health nurses to go through care plans. We did that in my ward round, and that's about all we discussed. I put all this stuff to them, and they sort of said, well, it's not our remit to, you know, determine your ICB. It's the remit of NHS trusts, not us as a multidisciplinary team. 1.4. Failure of Section 117 aftercare planning, a fundamental flaw. The most critical legal consequence of the commissioning error is the resulting impossibility of formulating a lawful discharge plan. Section 117 of the MHA 1983 imposes a mandatory joint statutory duty on the responsible commissioner and ICB and the relevant local social services authority to provide aftercare services to patients detained under sections such as Section 3. These services, which must be provided free of charge, are defined as those which meet a need arising from the person's mental disorder and reduce the risk of their condition deteriorating, thereby preventing readmission to hospital. This includes accommodation, by the way. The law is clear on identifying the responsible bodies. For the local authority, responsibility lies with the authority for the area in which the patient was ordinarily resident immediately before being detained. In this case, Bristol City Council. For the NHS body, the WHO's guidance confirms that responsibility lies with the ICB that was responsible for the patient at the point of detention. In this case, the ICB for Bristol area, that commissions AWP NHS. Lawful Section 117 aftercare plan cannot be formulated without the active participation, cooperation and legal agreement of both of these statutory partners, that's the Council and the NHS. The commissioning dispute has made this legally impossible, with the incorrect ICB Devon Partnership Trust identified and the correct ICB not engaged. The two statutory partners cannot convene to lawfully discharge their joint duty. The paralysis in the discharge planning process creates a direct and unlawful barrier to the patient's release from detention, as a comprehensive and properly funded aftercare plan is a prerequisite for safe and lawful discharge. breach of Article 5 of the European Convention on Human Rights, detention not in accordance with the procedure prescribed by law. The culmination of these procedural failures amounts to a breach of the patient's fundamental right to liberty as protected by the Human Rights Act 1998. The Article 5, paragraph 1 of the ECHR states that everyone has the right to liberty and security of person. No one shall be deprived of their liberty, save in certain specified cases in accordance with a procedure prescribed by law. Jurisprudence, which is a great word from both domestic courts and European Court of Human Rights, has established that the concept of lawfulness under Article 5 requires strict adherence to the procedural and substantive rules of domestic law. The MHA provides a comprehensive and exhaustive legal framework for detention. Any significant departure from its procedures risks rendering the detention arbitrary, thus unlawful. The continued detention in this case has become arbitrary. A detention that may have been lawful at its inception is rendered unlawful by its continuation in the face of a known fundamental procedural defect that the authorities have failed to rectify. The collapse of the administrative framework required to plan for the patient's discharge means the detention is no longer for the sole therapeutic purpose of treatment with a view to discharge. Instead, it risks becoming arbitrary warehousing. The legal pathway to release is blocked by the inaction of the very state bodies responsible for administering the detention. This failure to adhere to the core principles of the MHA, namely having the correct statutory bodies in place to plan for aftercare and discharge, means the detention is no longer being conducted fully in accordance with the procedure prescribed by law. This constitutes a violation of Article 5, paragraph 1 of the ECHR, the principle established in this case, such as this random case law, blah, 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 underscore that procedural failures can violate the lawfulness of a detention are directly applicable here. If you know what violate means, please send me a postcard because I don't. Section 2, breaches of duty and regulatory failings by AWP, NHS and DPT. So failure to resolve inter-trust disputes, a breach of NHS policy. The inaction by both AWP NHS and DPT NHS since been made aware of the commissioning dispute on the 22nd of July constitutes a clear breach of established NHS policy and principles. The foundational principle of all NHS guidance on interagency disputes is that the safety and well-being of the patient is paramount. No assessment, treatment or care planning should ever be delayed because of uncertainty or disagreement over funding or responsibility. That's why they did my care plan in the last ward round, went through it as a collaborative document, asked for my input, because that's sort of the main grounds for negligence, is that that hasn't been done with the oversight, and their excuse will be that Teams wasn't working that day. It was glitching out for some reason, so they claimed, which is why the NHS, my key worker or care coordinator as it should be called, or an out of area repatriation coordinator, like nobody was present from either trust, so they kind of didn't have to err on either side of the fence, and they tried to not be negligent by completing my care plan. Where such a dispute arises, the guidance mandates that one of the commissioning bodies must accept responsibility on a provisional without prejudice basis to ensure continuity of care while the issue is formally resolved. The failure of both trusts to establish such an arrangement since the 22nd of July is a flagrant breach of this core duty. Furthermore, the NHS provides clear dispute resolution pathways to be followed in such circumstances. The standard NHS contract, which governs the relationship between commissioners and providers, includes a formal three-stage dispute resolution process involving escalated negotiation, mediation, and if necessary, adjudication. The failure of both trusts to invoke the formal process instead allowing the situation to stagnate represents a serious governance and procedural failure that has directly harmed the patient's interests, the inadequacy of the PALS response and the breach of NHS constitution. The response from the Patient Advice and Liaison Service PALS teams at both trusts represents a distinct service failure and a breach of the patient's rights under the NHS constitution. PALS is specifically designed to provide on-the-spot help and to negotiate immediate solutions for speedy resolutions to problems, particularly where a patient's issue is urgent. The NHS Constitution for England explicitly grants patients the right to have any complaint acknowledged within 3 working days and to have it properly investigated. While acknowledgements were received following the formal complaint on the 28th of August, the subsequent and ongoing failure to provide any substantive response, investigation or resolution is a clear violation of this right. Standard NHS complaints procedures indicate that a full response should be provided within an agreed time frame, often around 25 working days, and that the complainant must be kept informed of any delays. The extended silence from both PAL teams is an unacceptable failure of the service they are mandated to provide. The pattern of inaction, first from commissioning teams, then from the PALS teams, points towards a systemic organisational failure of communication, governance and accountability between the two trusts. 2.3. Breach of the statutory duty of candour. The collective silence and inaction of the trusts can be framed not merely as poor customer service, but as a breach of their statutory duty of candour. This elevates the issue from a simple complaint to a significant regulatory failing. Regulation 20 of the Health and Social Care Act 2008, that's governing regulated activities. Regulations 2014 imposes a legal duty on all registered providers to be open and transparent with patients when a notable safety incident occurs. A notable safety incident is defined as any unintended or expected incident that occurred during the provision of care which, in the reasonable opinion of a healthcare professional, could result in or appears to have resulted in moderate or severe harm or prolonged psychological harm. Compelling argument can be made that the unresolved commissioning dispute constitutes a notable safety incident. The incident is the administrative and governance failure to correctly identify the responsible commissioner. The resulting harm is the prolonged psychological harm described by the patients feeling vulnerable, worried and ignored, compounded by the legal uncertainty surrounding the detention and the lack of a lawful pathway to discharge. The Trust's duty under Regulation 20 was to promptly inform the patient of the incident, provide a truthful account of what had gone wrong, offer a sincere apology for the distress caused, and then outline the steps being taken to remedy the situation. An apology in this context is a mandatory requirement and is not an admission of legal liability. The complete failure to do any of this constitutes a breach of the duty of candour and a matter which is regulated and enforced by the CQC. Section 3, potential for litigation and legal remedies. Like a judicial review is something I'm interested in doing. I'm probably not going to try and, rinse money out of them, but judicial review is something which would compel lawful action, according to Gemini. The most direct legal remedy to resolve the current impasse is judicial review. This is a high court procedure through which the lawfulness of a decision, action, or crucially in this case, a failure to act by a public body can be challenged. The focus of judicial review is on the legality of the process followed, not the clinical merits of the detention. The grounds for judicial review would be illegality. The argument is that AWP NHS is failing to perform its statutory duty to act as the responsible commissioner, a duty that arises from the correct application of the law on ordinary residents. Furthermore, both trusts are acting unlawfully by failing to follow the mandatory NHS dispute resolution procedures. The first step in the process is to send a formal pre-action protocol letter to the chief executives of both trusts, clearly setting out the legal case and demanding that they rectify their failures within a short time frame, for example 14 days, to avoid the issuance of court proceedings. An application for judicial review must be made promptly and no later than 3 months from when the grounds for the claim first arose. A successful judicial review could result in a mandatory order from the High Court compelling AWP to accept its legal responsibilities and forcing both trusts to comply with the law. Claim for damages, unlawful detention and false imprisonment. Parallel to seeking a resolution through judicial review, is a strong basis for a claim for financial compensation for the harm caused by the trust's failings. The tort of false imprisonment is defined as an act by the defendant that directly and intentionally causes the claimant's confinement for which there's no lawful justification. The legal argument is that the detention, while potentially lawful at its outset, became unlawful from the point at which the trusts were made aware of the fundamental procedural flaw, the commissioning error, on the 22nd of July and failed to take any steps to remedy it. They can't not have been aware before this date, but that's kind of academic. Their unlawful inaction is the direct cause of the continuation of the detention in a legally defective state. Some more case law supports the principle that an unlawful administrative act that directly causes a detention can lead to liability or false imprisonment. The Trust would likely argue that the patient would have been detained anyway, and therefore only nominal damages, a token sum, are warranted, citing the case of whoever the fuck that was. However, this defence can be robustly challenged. The failure in this case is not a minor technicality such as an error on a form. It's a substantive failure that goes to the very purpose of the detention. The absence of the correct responsible commissioner is the precise reason why lawful planning for discharge under Section 117 cannot proceed. Therefore, the patient has suffered a real loss of a chance of a more timely discharge, a substantive harm that justifies a claim for substantial, not nominal damages. The award of substantial damages in PB versus the Priory Group Limited for unlawful psychiatric detention supports this position. I'll try and put a link to this document in there for Waitman's detention damages. Claim under the Human Rights Act 1998, compensation for breach of Article 5. So a distinct but related claim for damages arises under the Human Rights Act 98. Article 5, this time paragraph 5 of the ECHR, which is incorporated into UK law, provides that anyone who's been the victim of a detention in contravention of Article 5 shall have an enforceable right to compensation. As established in Section 1.5, the failure to adhere to the procedure prescribed by law renders the continued detention arbitrary and in breach of Article 5, paragraph 1. This automatically engages the right to compensation under Article 5, paragraph 5. The European Court of Human Rights has consistently held that administrative failings and unreasonable delays that compromise the lawfulness of detention can lead to an award of damages, as seen in the Brand versus Netherlands. How ironic, where a 14-month delay in a transfer was found to be a breach of Article 5, paragraph 1. This principle is clear. The state cannot deprive an individual of their liberty, then fail to properly administer the legal and procedural safeguards that are essential to that detention's lawfulness. Analysis of the potential value of litigation. Should a claim for damages succeed, a court would consider several factors when determining the amount of compensation. The quantum. These include duration of unlawful detention, the period from when the trusts were notified of the error, 22nd of July, until the date the situation is rectified. The nature of the breach. The court will recognise this is a fundamental failure of the statutory framework, not a minor administrative error which has left the patient in a state of legal limbo. Impact on the patient. The emotional, psychological harm is a key component of the claim. The documented feelings of being vulnerable, worried and ignored are crucial evidence of the anxiety and distress caused by being detained by services that are disregarding their legal duties. I could give you some more backstory on why I don't like Devon Partnership Trust, how they've unlawfully detained me in the past, or rather detained me without medical legal scrutiny, missed not once, not twice, not 3 times, but 4 times in 2019, as confirmed by Kitty Granger in a letter from the Mental Health Act Administrator in 2019, which I got in person when she said there's no medical legal scrutiny on any of your section checklists. It's a tool to make sure they work, but it could imply unlawful detention. Anyway, I've also experienced a loss of opportunity. The court would consider the loss of opportunity to have discharge lawfully planned and potentially expedited. They did say I was going to be only in this rehab for a couple of months in my, I don't know what the opposite of penultimate is, the ward round before last. But this time, the consultant psychiatrist didn't mention discharge at all. Vindicatory element. A court may also award damages to vindicate the importance of the right to liberty and to mark the seriousness of the public authority's failure to comply with the law. These legal actions are strategically linked. Successful judicial review would provide a High Court declaration that the Trust's conduct was unlawful, which would significantly strengthen the subsequent claims for damages. Section 4, guidance on next steps for a litigant. This is what I should really be doing. So from the PALS to a formal NHS complaint. Given the failure of the PALS teams to provide a substantive response, the immediate and necessary next step is to escalate the issue to a formal NHS complaint. This formalises the process, triggers mandatory procedure obligations on the part of the Trust. A formal written complaint should be sent directly to the Chief Executive of the Trust and copied to the Chief Executive of the other Trust. The letter should be structured, clear, reference the legal and policy points outlined in this report. A clear heading of formal complaint, detailed timeline of events, clear assertion based on 4 years of residence in Bristol, ordinary residence is established there. AWP is the responsible commissioner under the Care Act 2014 and who pays guidance. A statement, the failure of both trusts to resolve this issue is preventing lawful section 117 aftercare planning and is therefore compromising the lawfulness of the continued detention under MHA 1983 and Article 5 of the ECHR. A specific complaint about the failure of both PALS teams to provide a response, a clear statement of desired resolution, so an immediate joint decision confirming AWP as a responsible commissioner and a commitment from them to immediately engage with the clinical team in all aspects of care and discharge planning. Full written apology from both trusts for the delays, distress and legal uncertainty caused, and an explanation of the steps that will be taken to prevent a recurrence. Engaging with key bodies for support and scrutiny. Simultaneously with lodging a formal complaint, it's crucial to engage with external bodies that have a statutory role in safeguarding the rights of detained patients. IMHAs are a bit corrupt, the CQC are a bit useless, and the PHSO I've never engaged with, so maybe I'll bounce that around for a bit. Strategy for evidence collection, so yeah, same, keep meticulous records and use a structured approach, document everything, preserve written correspondence, log all verbal communications, document the impacts. That's the end of the document. It researched loads of websites. I'll put a link in the description. It researched like 100 and fuck knows how many websites. 125, yeah, so it's there. So, yeah, they didn't need any longer than me to work out what was going on with this detention. I'm not an expert, I'm not a doctor, I'm not an NHS commissioner, I don't have a six-figure salary, but I do just have a phone and the internet, which is all I needed, along with about 18 minutes of my time to adjudicate that what they're doing is wrong, and it means that I can't be discharged. It means that my treatment in hospital isn't being moderated and overseen by the NHS. It's just being orchestrated and governed by Signet, who did dutifully, complete my care plan during my last ward round. Got me to engage to try and, I think, just cover their backsides. And yeah, anyway, there's 52 minutes. 52. If you're still watching after 52 minutes and you haven't fallen to sleep, if you've got a smartwatch, see how long you fell asleep during that presentation. Let me know, because I've only had not very much sleep. 3 hours and 11 minutes of sleep. I wouldn't say I've got hypnotic amnesia, more a series of prescient flashbacks. But if you've watched for 52 minutes, thank you. And if you know how to solve this problem, litigate, or want to assist me with a judicial review in a way that's not going to be arbitrarily biased towards the integrity of Signet Healthcare, all the NHS trusts that might have acted improperly, then please do get in touch. I did speak to the police once on 101 the other day, but I haven't spoken to them since, during any point of my detention since July 2024, and I'd like to speak to them again if possible. If it's a criminal issue, if it is illegal and I'm falsely imprisoned, then that's a crime under common law, and maybe I'll go forward with judicial review and see if that works. But thank you very much indeed for your attention, and I won't waste any more of your time. You've been here for 53 minutes and 38 seconds, so thank you. Good morning. I'm going to go and drink some coffee, smoke this vape, and try and get myself back to sleep if possible, because it is now 3:15 in the morning. Cheers.